Judgment in the appeal, Levy and others, and Westminster Magistrates Court and the Government of Rwanda and others.
The Rwandan government requested the extradition of the appellants under the Extradition Act 2003 so that they could be tried in Rwanda for war crimes. In the extradition proceedings before the district judge in the Magistrates Court, the appellants contended that they should not be extradited because, contrary to the Human Rights Convention, they would receive a flagrantly unfair trial and they might well be tortured or otherwise mistreated. Much of the evidence which they wished to call to support their contentions was from witnesses who were not prepared to reveal their identity to the Rwandan government. The appellants argued that the evidence of those witnesses should be considered at a hearing by the district judge without any of it being disclosed to or heard by the Rwandan government, a so-called closed hearing. And they also said that it shouldn't be heard or seen by the Crown Prosecution Service, the CPS, who were acting for the Rwandan government. The district judge decided that she could not consider the witnesses' evidence in a closed hearing or make orders which ensured that the identity of those witnesses remained secret from the Rwandan government, so-called witness anonymity orders. The administrative court agreed that she could not have a closed hearing, but they considered that witness anonymity orders could be made under Section 87 of the Coroners and Justice Act 2009. On appeal by the appellants to this court, for reasons given by Lord Mance and Lord Hughes, we hold by a majority of 4-1 that the appellant's appeal should be dismissed, on the grounds that the district judge was right to hold that she had no power, 1, to order a closed hearing or otherwise limit disclosure of the evidence, 2, to order disclosure to the CPS on terms that the material was not shown to the Rwandan government, or 3, to make witness anonymity orders. The main judgment is given by Lord Mance, with whom Lord Reid, Lord Hughes and I agree. Lord Mance's reasoning on the 3 issues may be summarised as follows. 1. Section 77, subsection 1 of the 2003 Act gives a judge in extradition proceedings, quote, the same powers as nearly may be, end quote, as the Magistrates Court would have if the proceedings were a summary criminal trial. According to an earlier decision of this court in the Al-Rawi case, the powers of a court to hold a closed hearing is limited to exceptional circumstances, such as protection of children or where the disclosure would undermine the whole object of the proceedings. It would be contrary to the interests of justice to allow a further departure from normal principles of open justice, because, in this case, the closed evidence could not have been properly tested if it was only limited to a closed hearing. 2, as the proceedings were in reality between the appellants and the Rwandan government, who were represented by the CPS, the district judge had no power to order disclosure to the CPS on terms that the CPS did not give disclosure on to the Rwandan government. 3, as was now accepted on all sides, the district judge had no power to make a witness anonymity order in light of the wording of Section 87 of the 2009 Act. Lord Hughes also delivers a judgment with which Lord Mance, Lord Reid and I agree, dealing with the interrelationship of extradition proceedings and subsequent immigration and human rights claims, and also discussing more fully issue 3, that is, the power of the court under Section 87 of the 2009 Act to admit anonymous evidence in extradition proceedings. Lord Toulson dissents on issues 1 and 2 on the basis that there should be an exception to the open justice principle where, as in this case, not ordering a closed material procedure or not prohibiting disclosure to the state requesting extradition would facilitate a potentially serious infringement of human rights. However, Lord Toulson agrees with Lord Mance and Lord Hughes on issue 3. In the event, therefore, the appeal is dismissed. The court is now adjourned.